Last week, jurors found Dzhokhar Tsarnaev guilty of 30 out of 30 indictments he faced in the 2013 Boston Marathon bombing. Now comes the penalty phase of the trial. Springfield Attorney Henry Rigali, a former federal prosecutor, came in to talk about the case, and I asked him his reaction to the jurors' guilty verdict on all counts.
I certainly wasn't surprised. I don't think too many people that follow this type of work or involved in it were terribly surprised.
Again, to the video, which seemed to play such a part in this case, I thought a particularly damning presentation made to the jurors, shown to the jurors, was a video of the defendant, Dzhokhar Tsarnaev, in a convenience store buying milk a few hours after the bombings. People have died. People are in emergency rooms and in surgery at that point. You know, he's very calmly looking, picking, selecting. No sense he's rushing in or out, just every day, something I got to do. I thought almost as much as seeing him put down the backpack and kind of surveying the crowd and apparently seeing he's near families, he's near little kids, to act that way, that must have gotten into jurors' heads, I would think.
Oh, I'm sure that it did, although I don't think you needed anything more barbaric or graphic as far as, evidence. It was just a terrible, terrible, unspeakable crime.
So now, the same jurors are back. They're tasked now to decide life without parole or the death penalty, the only options they have. Does the 30 out of 30 possible guilty verdicts, does that lead you in any way to think this jury is likely to vote for the maximum punishment of death, or is it a mistake to speculate along those lines, do you think?
Well, I don't know if it's a mistake or not. I wouldn't speculate. I don't think that the fact that the jury returned guilty verdicts on all of the counts gives us really much of an idea as to how they're going to handle the ultimate issue of death or life imprisonment personally. Again, the evidence was overwhelming. There really wasn't so much of a question about that. So, I mean, this is really what the whole case is it was all about. This is what's coming up.
And it seems to me in coming weeks and months, depending on what the final decision on punishment is and the appeals and the process that will follow, we're going to have a lot of talk about perhaps death penalty versus life in prison and what really is the right way to go. I know you've told me, you yourself, because of things that have happened through the years with cases and with appeals, you have questions about application of the death penalty. This issue is really going to come to a head for a lot of people now, isn't it?
It does. I think it will. What we're all going to see as citizens is our criminal justice system at work. Prosecutors presenting aggravating circumstances to a jury, saying this man should be put to death because A, B, and C, and defense attorneys trying as hard as they can to humanize their client, very difficult under the circumstances, but to present evidence to minimize the scenario so that they can avoid the death penalty. This is an unusual case, as we spoke before, at least in my opinion as a practitioner, because it really frames the debate. Many, many people are opposed to the death penalty for a variety of reasons, but many because of the uncertainty, the fallibility of our criminal justice system. In excess of 100 individuals have been exonerated on death row, generally and sadly, after serving lengthy prison terms because of new scientific evidence, forensic evidence has exonerated them. Now, these were people who were convicted in front of jury systems, so excellent prosecutors, senior defense attorneys, senior judges. Murder cases aren't tried by beginners generally. So you'd think that the system would be doing well there, and yet, after all of those protections, more than 100 people have been exonerated by subsequent evidence. So what that means for those of us like myself who are in the system is we have some real hesitancy because of the fallibility of it, to reach such quick conclusions, knee-jerk reactions about the death penalty. This case takes away that factor, the possibility of error. This man is clearly guilty, as all of us have seen, watching the evening news and clips of the case and so forth. It's just, there's overwhelming evidence, and the defense doesn't, dispute the fact. So the uncertainty element of the anti-death penalty people is not a factor. So it'll be a very interesting debate now to see what's going to happen with the death penalty.
Well, let's talk a minute. Let me set it up, because we do have the two very stark possibilities. Life in prison without parole, probably at a supermax, probably the supermax in Colorado, which everything I've ever read, it's a bleak, awful place to spend your days. Or the death penalty. There are people who say, this is what this person wants, to be a martyr for their cause. The death penalty would be just what they want. Let's take this young man, lock him away for what could be 40, 50, 60 years. Who knows if he were to live into his 70s or 80s. Really, people are going to focus in on, and I think there's going to be tremendous public discussion and debate.
Well, I agree. I think for the obvious reasons, there'll be tremendous debate about this. And I don't, I'm just as a citizen, I certainly don't have the crystal ball here. But this whole concept of martyrdom, and to what extent that plays a factor, and to what extent the criminal justice system should take into account that type of intangible. We should not put him to death because to do so would make him a martyr and, make him a hero in the minds of these warped people that even think of doing these things. To what extent that comes into the actual decision-making in a murder case, I don't know. But it'll definitely be a case with a lot of debate.
So the final part of the trial, the penalty phase, deciding life or death. The thought is that could well be much more involved and take a lot more time than the roughly 3 to 4 weeks that the verdict phase took up. What's your sense?
Well, I don't know about the time, but it'll definitely be an interesting part of the case. Now, just to sort of frame the stage, if you will, the prosecution, this man's been found guilty, no question about that. And so the prosecution has to go first on its evidence. It has to convince a unanimous jury, 12 out of 12. I understand there are 7 women, 5 men. All from a New England area. There's some regional value systems there. Massachusetts is a liberal state generally, I think, liberal legislation. To what extent the people that are on the jury are going to reflect that sort of value set, I don't know. But the prosecution's going to go first. They are going to present aggravating evidence, things that say, this is why we, the government, think this man should be put to death. Obviously, the defense is going to be trying to mitigate and minimize a little bit. He's a human being. He was under the influence. He's, this, that, and the other thing. The extent to which the defense may introduce these other arguments of, don't let him become a martyr, and it's miserable to be in Supermax in Colorado and so forth. Those, I don't know the extent to which those points will be brought up, but I'm sure the defense will bring in experts to talk with the jury about the youth of this man. He was 19 years old at the time. I don't think any of that excuses the conduct by any means. Every day right here in Hampden County, people who are 18, 19, 20 years of age are being sent to prison for lengthy prison sentences, notwithstanding their youth and all of the fallibility and poor judgment that we all had as youth. But I think that the experts are going to weigh in for the defense on this, and it'll be very interesting to see how it all shakes out.
Well, Henry Rigali, thanks for coming in. Thanks for your perspective, sir.
Thank you. My pleasure.